Have you wondered what is the definition of contract? The definition of contract is a legally enforceable agreement between two or more parties, where each party assumes an obligation to perform or refrain from performing certain actions. Contracts are the cornerstone of commerce and legal relations, providing a framework for individuals and organizations to enter into agreements confidently, knowing that legal remedies are available in case of breach. There are 5 essential elements of a valid contract: offer, acceptance, consideration, intention to create a legal relations, and the capacity. Number 1. Offer. One party, known as the offerer, proposes specific terms for an agreement to another party, the offeree. The offer must be clear, unambiguous, and unintended to create a legal obligation once accepted. For example, I offer to sell you my car for 20,000. For the legal principle, an offer must be communicated and sufficiently certain in terms of price, subject matter, and essential terms. An offer differs from an invitation to trade, for example, a shop displaying goods for sale, which is not an offer but an invitation to make an offer. Number 2. Acceptance. Acceptance occurs when the offeree unconditionally agrees to the terms proposed by the offerer. This must be communicated effectively, and any modifications or conditions added during acceptance would amount to a counteroffer, not acceptance. For example, I agree to buy your car for 20,000. For the legal principle, acceptance must be an unequivocal assent to the offer, and the mirror image rule applies, meaning the acceptance must match the offer's term exactly without any variation. The third one, consideration. Consideration is something of value exchanged between the parties. It can be money, goods, services, or even a promise to refrain from a particular act. Consideration distinguishes a contract from a gratuitous promise. For example, exchange for receiving 20,000, the seller agrees to transfer ownership of the car. For the legal principle, consideration must be sufficient but need to be adequate, meaning that the court will not typically assess whether the consideration is fair but only whether some value is exchanged. Number 4. Intention to create a legal relations. The parties must have the intent to create a legal obligation enforceable by law. Social or domestic agreements, such as between family members, are generally presumed not to have this intention unless proven otherwise. For example, a contract to sell a car between two parties in a commercial context is presumed to have a legal intent, unlike a promise to visit a relative. For the legal principle, the court distinguishes between domestic agreements which lack legal intent and commercial agreements where legal intent is presumed unless repeated. Number 5. Capacity. The parties entering into the contract must have the legal ability to do so. As for minors, mentally incapacitated individuals and intoxicated persons may lack the legal capacity to form binding contract. For example, a 16-year-old cannot enter into a binding contract to purchase a car unless it is for necessities, food, clothing, and shelter. Types of contract. Express contract. In express contract, the terms are explicitly stated either orally or in writing. The parties communicate their intentions and obligations clearly. Example, a signed employment contract that outlines salary, work hours, and job responsibilities is an express contract. Legal principle. Express contract leave little room for ambiguity as both parties clearly state their intentions. Court typically enforce such contract based on the explicit terms agreed upon by parties. Implied contract. Implied contract arises from the action, behavior, or circumstances of the parties rather than through spoken or written rule. These contracts are inferred from the conduct of the parties. For example, if you board a bus, it is implied that you agree to pay the fare even though no express agreement is made. Here is the visual example. Bilateral contract. A bilateral contract is one where both parties exchange promises to perform acts in the future. Each party is a both promiser who makes a promise and a promisee who receives the promise. For example, a contract where a company agrees to deliver goods and the buyer agrees to pay for them upon delivery is a bilateral. Unilateral contract. A unilateral contract involves one party making a promise which the other party can accept only by performing a specific act. For example, someone say, "I will pay 500 to anyone who finds and returns my lost dog." In a legal principle, a unilateral contract becomes enforceable when the specific act is completed. Void contract. A void contract is one that is not enforceable by law from the outset. This contract lacks essential element or involve illegal subject matter. Example, a contract to perform an illegal activity such as selling counterfeit goods is void. In a legal principle, court will not enforce contracts that are for illegal purposes or lack of a lawful objective. Voidable contract. A voidable contract is a valid contract that can be cancelled or voided by one of the parties due to specific legal ground such as misrepresentation, under influence, or duress. A contract signed under a threat of harm, duress is voidable by the coerced party. For the legal principle, voidable contracts remain valid until the party with the right to avoid the contract exercises that option. Enforceable contract. An enforceable contract is one that meets all the legal requirements and can be upheld in a court of law. Example, a written contract to sell a house which is valid and enforceable because it complies with statutory requirements. Legal principle. Enforceable contract comply with legal formalities such as the statute of fraud which mandates that certain contract must be in writing to be enforceable. Unenforceable contract. An unenforceable contract is valid but cannot be enforced due to technical reasons such as the lack of required formalities. Example, an oral contract to sell land which is unenforceable because contract involving land must be in writing. In legal principle, they need to meet the legal formalities such as requiring a written agreement for land transactions. Executed contract. An executed contract is one where all parties have fully performed their obligation. Example, a contract for the purchase of goods where the buyer has paid and the seller has delivered the goods. In legal principle, once a contract is fully executed, the obligations of the parties are discharged and the contract is considered completed. Executory contract. In an executory contract, one or both parties still have the obligation to perform in the future. Example, a pre-order agreement for goods where the buyer has paid but a delivery is scheduled for a future date. In legal principle, an executory contract remains binding and the parties are legally obligated to fulfill their remaining duties. Classes of contract. There are three classes of contract. Contract of record, specialty contract, and simple contract. Contract of record. Contract of record arises not from voluntary agreement but from judicial proceedings such as a court judgment. For example, a court order requiring one party to pay damage to another. In legal principle, contract of record are legally binding and enforceable in the same way as contract, even though they are created by judicial authority rather than mutual consent. Specialty contract. Specialty contract, also known as deeds, are contracts made under seal. They do not require consideration to be enforceable as the formal seal itself indicates the intent to be bound. For example, a deed of property transfer. Simple contract. The definition of simple contracts are those not made under seal. They may be written, oral, or implied by the conduct of the parties. For example, an oral agreement to repair a car for a fee. In legal principle, simple contracts are the most common form of contract, requiring mutual assent and consideration for validity. That's it from us, Group 1. Thank you!